Good morning. This is April TCG. What's up, my TCG fam? We are covering the YSL Trial and what's going on this morning. Okay, actually, what's been going on this whole week. So we're gonna just talk about it. And again, this is for a conversation. We are, I welcome all point of views. So come on in and let's talk about it. All right, so there's Mr. Zachary. I think his first name is Quintarius. So Zach, I'm gonna call him Zachary. Okay, so and I think it's little D is what they call him. However, he is still going through his sixth stage now. He, of course, he's been subpoenaed, as most of you that's following the trial already know. He's been subpoenaed just like Fanny was subpoenaed. She didn't show up. He didn't, so they um, arrested him. Anyway, he's got some illness. He's in the hospital, in and out of the hospital, you know. So the judge and Miss Love, they're wanting to force him to come in, even though he's sick and right now even in the hospital. And Miss Love is like trying to force him to come in, even though the man is in the hospital as we speak right now. But because Miss Love wants him in there and the judge does whatever Miss Love says, they're trying to get him in there. So that's pretty much what is going on this morning, which is crazy. I wanted to come live today because I think that the stuff I've been hearing about is crazy with Fanny and her Fanny not showing up for the hearing. I think it was last Friday that she was subpoenaed to come to and testify. And Fanny did not bring her Fanny to court where she was subpoenaed. So currently, I don't know the status of it, but we'll check it. She is trying to fight the subpoena. But Zachary, he was subpoenaed for this YSL trial to testify. He has an illness that is keeping him in the hospital, and he was arrested. Like any one of us, if we are subpoenaed by the courts, and if we don't show up, we could risk the chance of being arrested. But not Fanny, because she just rules and makes her own rules for herself. Okay? She's the same person that says she did not know that it was inappropriate to have, or she didn't, I'm not going to put words in her mouth. She didn't use the word inappropriate. Um, and these are not her words verbatim, but she pretty much said um, she didn't know anything was wrong having an in office affair. So that's the same person. So we're dealing with corrupt Georgia and we're seeing it right in front of our eyes. Everyone is seeing it right before their eyes. Everyone is seeing it. So we're going to go into um going to start right here. And you know what? My backdrop is not very straight. I'm going to see if I can do a little something with it because it's going to get on my nerve. Let me just over here make it a little neater. It's kind of all over the place. All right, let's see if that helped any. Trying to get this wrinkle right here out, but I don't think that's going to work. Nope. Let's see. Did that do anything? It didn't do anything. So we're just going to sit ourselves back down. And that's just what it's going to have to be. All right. So let's go ahead and share the screen. And let's get a little frustrated with the DA and the state, because what's going on in this courtroom is, as we know, unbelievable to a lot of people. Those of us who are here in Georgia, we already know. We already know how these people that we vote in, we vote them in. So we have that control, but we're so darn divided. If we would just, look at everybody's point of view, because everybody has a different, every group of folks have a different point of view. So if we kind of stop being so selfish and just, oh, this is what I want, and and look at other people's point of views, then it may not be so we'll get the right people. We'll vote the right people in. So think about that. Don't just be so one-minded and just vote just because because some people, they'll like say they're going to vote for a certain person, and this is including like the local. I'm really speaking of the local elections, but you have your mind on someone and you just never let that someone leave your mind. No, don't do that. Do your research, listen to other people's point of view, because you might learn some things that are important, because we have voted in the wrong people locally. I'm referring to like superintendent, DA, Fannie Willis. We got to really make the right decisions in 2026 is the most of the local, well, the ones that are most important to me, the election that is most important to me, the local election, that's 2026. So all right, so we're gonna go. Let's share my screen. And what's up? Good morning, everybody. As you come in, please like the video. I really appreciate you coming in to join us, and we're gonna go ahead and get started. And I hope that your morning is going super.
Okay, here's one for every, that works. All right, Miss Love, what do we know about witnesses for today?
So if you can hear
We have
anything else other than
Mr. Sprinkle. We will be
the video,
presenting an
let me
order
know so I
or a
can
motion for an order,
adjust
a
a
proposed
device
order for the
somewhere,
court to
because
hear
I want to make sure that we're on the
from
same
the
page and that
staff
we're
at Grady
all,
about
you
Mr.
know, and
Zachary.
we all can chill
We
out.
don't
Some
know
of you
how
are
the
at
court will
work,
handle
so
that, but we'll move
let's, if
Okay.
you want to
because we
send a
don't yet have
message,
his
let's
stat. We don't
converse with
have.
each other,
We
and
have word from the sheriff's office about
let's
his
discuss our
status.
point of views.
But
So right now
the
they're talking
captain was
about
speaking to
the
a charge nurse, and
well, let's listen.
looking at what was available, it was not evident to the person I was speaking with what was keeping him. So I will be attempting to have his treating physician.
Okay, they're talking about Mr. Zachary, little D, who's in the hospital, who was subpoenaed, remember? So that's who they're talking about right now.
Perhaps if we can get that
This is
done,
we're about
address the matter,
well, let's
and
just
whether or not
talk
he's
too much.
able to safely either come testify or be released. The reason I say that is that he had,
And you
when
can
he
just
first
tap on the screen
was taken into custody,
twice.
he
and
was taken down
You
to
can show
Grady,
support that way. It just likes the
and
video.
released.
That's
And
all. It
when he was
doesn't
set, it was as
anything
in
else.
2
It just
days'
likes the
time,
video.
and then he was
It
set to
helps
come
the channels, our
here,
channel
obviously.
grow,
But
so.
then he was taken back right before, and they kept him because of that. So, given the set of circumstances that we have, we'll be asking the court to seek
Oh, and
from
also
them,
this is
from Grady itself,
this week
if they
is
will
starting
apprise the
the
court
month of October.
his status and
So the
his
whole month of October
availability, his
is let me just
tentative
pause this for a
release
second. I'm
date. And
sorry. So the whole month of October is Veterans Suicide Awareness Month. So be sure to support your local veterans, support it because there are a lot of, unfortunately, suicides that occur with veterans. So be sure to support them.
I won't speak more on it. I'll just present a motion to the court regarding that, and the court can decide what the court wants to do.
All right, I'm not quite following why we need a court order for that if his attorney who is representing him is okay with the doctor in the hospital providing information, which so
Well-
far they have been.
True. And so it would be a matter of, I guess, a Zoom call or something, but I want the person, the treating physician, to directly relate to the court what his current status is
This is
in
so
terms
good. This
of
smoothie I made this morning.
releasability and ability and an impact on
This is,
coming to testify.
Frozen spinach
All right,
with
good morning,
blueberries,
Mr. Shive. Do you have anything to
strawberries.
add to this?
Protein shake,
Twice yesterday.
a protein,
5:15
scoop of
yesterday.
protein powder.
Told me he's got
And I
two
put in a
medical
little bit
scenarios.
of vanilla
One,
powder.
he's got real
It's
low
no
blood
sugar.
pressure.
Hang on. Can y'all all hear him or
Just a little bit.
come on up to the
And
mic if
it's
you don't
really
mind?
good. Oh, and almond milk. It's really good.
And when you're saying you spoke with him, do you mean Mr. Zachary or Mr. Zachary's doctor?
I spoke to Mr. Zachary about 5:15, and
Okay,
he says they had planned on releasing him, but he said they checked his blood pressure and it's low. They have
Okay.
to get it up. The
okay.
second thing is he has a problem with a certain blood count. I don't even know what that is. I mean, and he started explaining it, but as a layman, I wouldn't know. But he said those are the two things that are holding him right now.
Okay.
And then once he's released, but I don't know when that's going to be.
So because I'll just stand on what I just said. And before I do anything with his doctor, like if the
Did Miss Love
doctor
say
comes
she'll stand on
or
what
is
she
able to reach out to us, I'll have Mr. Shive notified and brought in and deal with that then.
I don't,
So-
the doctor's not going to speak to you without his permission and me
They
being
do
there.
some
But
force a sick person.
from what I gather,
to court.
talking to the other
Y'all
doctor
remember this?
initially, his
You have
situation is
you've been
tenuous. It
subpoenaed
goes
to
back and forth.
testify.
It's stress level, and I've
Don't
done a
think you're
bunch of
gonna use
research
those
on it.
little
and it's-
excuses. Oh, I'm sick.
it's
Oh, I have
his
pneumonia.
situation.
I have
Like he's had 3 blood transfusions in the
better have
last month and a
COVID,
half, complete blood
'cause-
transfusions.
and that
so
they'll probably
he-
say, oh, wear a
Sickle cell
mask.
anemia is a blood disease.
You've been
It's-
subpoenaed.
It's messed up. And
They're gonna have
the
you
family's-
in there.
He's been in intensive care, so
I'm telling
and
you,
then
let me
they-
tell you
and
something.
it was indicated by
the
the
week of
DA.
my
they put him
wedding,
in jail. He had
I was
he had
actually
a crisis. They took him to Grady.
um,
It stabilized. They took him back to the jail. He had another crisis. They took him back to Grady, and that's where he's been.
traveling for my
So, and
wedding,
then
and
If he comes here, what I would like
I was
is
assigned
us, and
jury
is
duty.
within your discretion.
This look at him. This is
to
the guy
have
that
a hearing and let him testify. And
shot
let
the
the DA
middle
ask him
finger at the
questions
camera
about
last
what he
time.
knows and
They
see
did this
see
to
how
him.
he
He's
stands
in
up under
jail right
that.
now.
And
We're not going to
Anyway,
do that.
so,
I mean, we're just going
yeah,
to
they
have him
called me
testify.
in
We're in the
for
middle of the
jury
trial,
duty.
so there's no point in doing a pre-hearing about that.
to see if he survives it or he has another crisis. But if that
Regardless, we'll do that.
So I had to, and I
in the
called
trial
and told
itself.
them, and they said that I had to actually
There's
send
no
proof.
point
So I
doing
had to
it
send a
twice.
copy of
well, just to see
the
how
lady who was in the
see what his
state
testimony would be. 'Cause it's
where we were
indicated
getting married,
That's not how
who
trials
was
because
work.
handling
he's
the
real sick.
marriage
And if we have
license
a problem
and things
here,
like that. So
I
I
don't think
had to
you'd want to
get
have it from the jury.
her
But,
to
I'll put it on the record, and whatever you decide to do,
send
obviously we'll
documents
go
to
along.
me
Okay.
that I
You know,
provided to the courts
Keep me. I
here
have 2 cases
to
upstairs.
show them that I
plan on being
why I
here for a
couldn't
while.
Okay,
because of my wedding, why I
Yeah, I
couldn't
know
Yes.
that.
attend jury duty.
I know that Mr. Shive's concern
Don't play about.
stated to the court has been his client going back to the jail. And I know that that has been the concern that Mr. Shive has
I
expressed.
really want this
to
guy.
the,
I want
hospital
to see what
personnel,
he's got to say,
But
or what his
as I stated
interrogation
before,
videos like Lil Woody. It
if
must
he
be
is
something
to
like
come
that
here
because they
following
really
the hospital, there's no
love
need to
really
go back
wants this guy
to
in here
the jail if we.
trying to
All
pull
right, and
someone
I
from
thought
the
y'all were going to
hospital
work
bring him into
something.
court.
I mean,
That's
let's
crazy.
imagine a scenario where he gets released from the
So he
hospital
must have
at
some
4:30
important information for the
or
state.
5. Then what happens? I thought the two of you were going to work out some kind of other
And, they said, they
arrangement
just said that
where
his family
he
did
is
not want
kept
him to,
in custody,
testify. I wonder,
considering
is
the
it because
issues
do
about
they not want him to testify
whether he's
because
going
of
to
his
appear
illness?
voluntarily
Or
or
do they not
not,
want him to
but
testify because
not
of,
in the jail.
they
That
just don't
has
want him to be
been,
involved in the whole
dealt
situation?
with,
You know what I'm
and that has
saying? It's,
been,
I wonder.
That's what we want.
He must have
So he
said some
can go back to
crazy
his house.
stuff.
You
He
want to
would
put a GPS monitor?
He would not be at his house. He would be, we would still have to keep him in custody somewhere outside of a jail, I suppose. We could work on
So
that and
have
talk about
y'all-
that later. Because
Well,
we
I don't
had,
know about working on it and talking about it later, because it sounds like whatever, this is a fluid situation, and the kind of release, nobody seems to know when that's going to occur. And if it occurs at a time when he can't be brought immediately over to testify, then there need to be other arrangements in place. And you say we've worked that out, but then it doesn't sound like y'all have worked
No,
that out.
actually, it has not been Mr. Scheib and me. It has been the DA's office and the jail in terms of who or how they would, how we would handle his custody. And if he's released back to the jail, I can
That
talk-
seems like the kind of thing that, I don't know, a judge's signature needs to be upon.
We have not yet.
Okay,
have
so
been
you just
discussing
said you
it.
worked it out.
I'm saying that there have been discussions.
Mm-hmm.
I will leave it at that, and I will present to the court whatever the result of those, I believe the conclusion of those discussions are before he is released from the hospital.
It's real simple for me. I would like him released and go back home and be with his family so they can take care of it.
I know what you want, and based on the information that was in the affidavit in support of the material witness warrant, if he goes back to his family has no intention of, at least based on what's in the affidavit, of having him come testify.
The court could order it, hold them in contempt if they do not, and put a GPS monitor.
Okay, I told y'all to work that out like 2 days
How do you
ago.
expect someone to, I can't stand when the judge
We have been,
says that to the defense, like, she's like, oh, I told
we've been
you.
talking, and as I have
Amongst
said to
yourselves.
Mr.
How will
Scheib,
you work anything
we
out
have
with Miss Love, period.
his continued
She can't even, Miss Love doesn't even treat you
position
with
is
any authority, Judge. So how in the world
only
do you
about
think
him
the
being released and
defense
not testifying.
All right, if you
is
can't
going
work it
to
out,
work
then just
something out
present
with
something
Miss
else
Love,
to
of
the
all
court,
people?
other
That's
arrangements.
crazy to
Because I
say
don't
that
think that it
and
would
put
be
the
appropriate,
defense or even
considering
this,
the health
will be
situation,
attorney
for
in
him to
that
go back
type
to
of
the jail
situation.
either.
There's
But
no
there's
such thing as
something
working
between
something
the
out with
two,
this lady.
between total release
Crazy.
and he's in the wind because his family wants him
Not to testify.
far away from here and in the jail. There's something in between those two.
Okay,
Yes, Ron. Thank you.
okay. I have 2 court cases upstairs. I'll be back.
All right.
Thank you.
Your Honor, I'd like to put something on the record. Is this
All
an
right.
appropriate time?
Sure.
Okay. I fully understand that we are not a party. When I say we, I'm talking myself and my client, to anything going on with Mr. Zachary and the DA's office. However, it is my job to ensure a fair trial for my client. I am putting everyone on notice now. Your Honor, I don't, and I'm not casting aspersions. I don't know how much, if at all, judges know the discovery and the backstory of everything.
I don't.
Okay, all right. Well, this is what
That's between y'all until it gets presented in the trial.
Okay,
Or
so-
unless you bring an issue to me.
well, that's why I'm bringing this issue. Okay, Mr. Zachary, in statements in 2015, says a bunch of nasty lies about Mr. Stillwell. He blames Mr. Stillwell for everything except the JFK assassination. And my concern is, and I'm going to deal with that on cross-examination. I'm going to,
I hope you do.
that's not going to be a problem. However, if those lies come out and I am not able to cross-examine Mr. Zachary due to him being unavailable, due to medical situation, due to anything like that, and I don't know about his medical, I'm just hearing about it just like you. But if that happens, there's going to be no one ringing that bell. There's going to be no limiting instruction that's going to protect his due process rights, his rights to confront his accusers, his cross-examination rights. And it's going to lead to me asking for a mistrial again. And the state is on notice at this point that by calling Mr. Zachary in this state, and I don't know what his state is, but they seem to know, they are on notice that something could happen. And I'm not the one calling him to the stand, but if his direct testimony comes in or his prior statements come in and I don't have a chance to confront him about those lies, we are not going to have a fair trial. And I'm just putting it on the record now so everyone knows what my stance on that is.
All right.
Thank you.
Thank you. And again, I don't know what exactly his situation is. I've been told sort of varying things. There is, and I guess the most appropriate thing might be to just hear from the doctor, but if he is in a condition where testifying at this trial is risky and he may make it through half the testimony and not all of it or something like that. I mean, there is the possibility of taking his deposition to preserve his testimony, which then all of the attorneys would be present for, and you can do a video deposition. And then if for whatever reason he gets through part of it and not all of it, then it doesn't get used. I mean, that's a possibility.
Your Honor, there are just a couple of things that, in the court is correct. And that is, those are things that we have, tossed around.
Yeah.
I will say
But
this.
the state's
If something
bigger
happens to this
concern
man,
is that
Mr.
given
Zachary,
the
if
commentary
something
made by
happens
Mr.
to him
Zachary's
while he's
father, when we were trying to reach him,
testify,
that he was going to reach out to Mr. Sharp and Mr.
if I were
Steele.
his
I don't know
family, I would
why,
sue
but that's what he
the
said.
hell out of the state of
when-
Georgia.
And he
Because this
insisted
is
that we
crazy.
could not force
And then keep in mind, now this is
Mr.
something
Zachary
from
to come and
2015.
testify.
So even if he
And
did
given that
do what Moody
there
did
seems
and go into an
there seems to
interrogation
be
room and
pretty
just
open communication
say
between
what,
Mr.
just throw
Shive and
everybody under
counsel
the
for the
bus, whatever.
defendants. They
It's still
probably have an even
2015,
better
and
grasp
I
of
don't
what's
want to
going on with
testify on
him than
anything
even we
that I
do.
have
But what we do know
even
is that
witnessed in
there are people
2015.
down there who are monitoring
So
him.
that's-
And the person with whom I spoke yesterday said that person is not a doctor, but that his vitals on the chart looked normal. And that there were,
with that,
there had been the
the
representation by
courts
Mr. Shive
knowing
that if he goes
this
down
man
to
is
the
in the
jail,
hospital,
he's going to
that
die.
he
And there are
has
28, all of
illness,
these things.
and
And so it
stress
perhaps
causes
makes
illness too. So if you already
certain
have a serious
people,
illness and you're
protective of keeping him there
to
and not
testify,
realizing the reality of this
about
circumstance, that
murder
it
situation
appears that
from
whenever it
2015,
comes close to the
are
time
you
that
crazy?
he has,
That's
so
serious.
Yeah, I
There's that.
realize that
Stress.
this
But
could
we have
just
to
as
consider-
easily
If I were
be a
him,
convenient excuse.
being in and out of
I
the
mean,
hospital like he is,
but we've
I
been
don't know what the real
actually
situation is.
still
and we
file
have
suit.
been,
I would still sue the
we
state
have
of Georgia.
been
That's what I would
talking
do.
about all of that. But what I do know is that Mr.
Just
Shive
for,
has told me
stress, mental
flat
stress.
out, my
no,
client will not
that's personal
testify.
injury,
And he's given me the reason
my
that he
opinion.
believes. And
That's crazy.
like I said, I'll just leave it at that. And it's not the reason that he just represented.
Okay, well, I have also not been presented with any sort of an immunity order,
We
something.
have that.
Okay,
And it's the same, it's just a standard motion under the statute and a proposed order and an agreement from Mr. Shive and his client to sign. So, and again,
okay, so have the terms been worked out
But I think
between
before
of
you
the
go
order,
signing
whatever the
some
conditions
immunity
and things
deals or
like
whatever with
that?
the
Did you
state
and
of Georgia,
Mr.
because
Shive work that out?
they're gonna
no,
hold you
Judge, we did
whatever
retract the language of the
you're
statute. There
agreeing to
wasn't,
do.
it literally says that he
So
cannot
just don't
be-
do it.
not
Don't
that
be
he
around the foolery.
the stuff to which he is.
All right, so you have not talked to Mr. Shive and Mr. Shive has not talked to you since yesterday afternoon when y'all said you were gonna,
We've
about terms?
we have been drafting it. We have not talked.
Okay, so how about talk to him when he gets back? Because he had a couple of other courtrooms to go handle matters in and he was coming back after that. And talk to him before you present anything to me.
Okay, but Your Honor, I would also say that, and I will do as the court has instructed, period. That's a full stop. The statute.
I love when attorneys say, I'll do I'll follow your orders, as if you have a choice. I mean, I guess you have a
No,
choice.
I'm-
I could hold you in contempt,
You-
but okay,
and
thank
that's
you.
not
I
what intend
appreciate
to have
that.
happen, and I don't mean to be or sound
Okay.
contemptuous. What I'm saying, Your Honor, is I don't want the rest of what I'm saying to be interpreted as if I'm going to do something else
Okay.
than what the court has instructed. All that I am saying, or all that I was saying, was that the 245507 has specific language,
Mhm.
and it instructs that the court knows that statute. So we are going to follow that statute, and we will talk to Mr. Scheib about what that means. And I don't know if there's something else that he intends to or wants, but whatever that is, we will discuss it with him. But the statute itself is pretty clear, and so we will do as I said, as the court instructs.
Okay. All right, there's a new motion in limine number 60 that I am just opening the email for. Is that something that we need to deal with this morning, or is that just something for our
No.
next non-jury day?
No, but I wanted to inform this honorable court that you motivated
Ah,
the people at our office.
okay, great.
Thank you. They said they are inspired by your words and they are ready to go. So thank you.
Good deal. Okay, well, we'll take that up whenever we have our next non-jury day, if it's just about upcoming evidence, but not immediately upcoming. All right. All right, are there any other, we told the jury 9, so we've got a few minutes before it reaches 9 o'clock. Any other matters we need to discuss?
Your Honor, we came in early specifically to discuss the
Yes.
objection that was raised
Okay.
by counsels for the defendants. And what I believe was happening, if I can summarize it clearly and accurately, on yesterday evening, we had Deputy DA Mike Sprinkle on the stand, who was asked a question regarding how it is that he conducts further independent investigations into the unindicted homicide cases that he receives in order to make those decisions that he makes. There was the objection, specifically when I asked Deputy DA Sprinkle how it is that he decides, with the thousands of jail calls, for instance, that he has access to, which ones are pertinent to to look at. And so there was this objection that we were bolstering, that it was irrelevant, and that we should not be allowed to do that. We should only be allowed to ask DDA Sprinkle what he did in this case. To that, Your Honor, to the extent that the defense has made relevant by accusing, in front of the jury, raising their defense of essentially selective prosecution and malicious prosecution by the state, it has not only made this particular testimony as to how DDA Sprinkle conducts his efforts to determine the proper charging decisions to make, not only relevant, but highly probative, and thus not a waste of time or confusion. For the defense to take the position that they are able to show that, or say that the state has essentially chosen to just go after their client because they wanted to get the big fish, and then to object when we try to show the repetitive nature
And you did.
and the consistent method by which DDA Sprinkle conducts his procedures, it is an effort to create a distraction on their part regarding selective prosecution or malicious prosecution, and then to have that argument unanswered on the part of the state. And that is, it goes against 24-1-1, which obviously says that the whole purpose of this process is to determine the truth. And so when the jury is trying to make a determination about what was done in this case, and essentially DDA Sprinkle has taken investigative
Get out of
steps,
here.
and
This is my dog.
he is showing his normal, consistent investigative steps. And for the defense to try and limit that showing to the jury, it's an effort to hide very relevant facts from the jury. When the defense is allowed to argue with respect to our officers who asked on cross-examination, how many reports have you done? Is this what you do in every report? And to essentially question the way that the officers normally conduct their procedures in order to make the jury believe that something untoward has happened, the state certainly should not be constrained from showing the standard nature and the reliability of the procedures that DDA Sprinkle used in determining how he ultimately makes decisions. So how the phone calls are obtained is just one thing that makes it credible. It shows that it is a part of his routine policies and procedures, and it is not distracting. It is in fact clarifying. And again, under 24-1-1, the state is or should be entitled to present its evidence that what the defense has now put before the jury by way of argument and cross-examination is very relevant. Their entire position is antagonistic to 24-1-1. And even if someone feels they've got a constitutional right to confuse, that's not what our rules of evidence require. And we would ask that the court allow us to continue the line of questioning that we have begun. We have said that we would make it targeted. We are not attempting to get information that is not pertinent in this case before the jury.
I mean, one of those
we are
burritos from
attempting to give the jury all of the information that they need in order to make
not Taco Bell,
proper decisions based on whole truths in this case. Thank you for allowing me to say that.
All right, thank you. Do you have any case law you wanted the court to consider?
Well, as to bolstering, Your Honor, that is what the defense has argued is happening. That has been the basis for their objection. And the first case that I have for the court, it plainly says that bolstering is when one witness testifies or comments on the credibility of another, or when one witness attempts to, after the credibility of something has been attacked, another witness, before it's time to do so, attempts to bolster the credibility of that other thing that has been attacked. So in this case, this is simply the state showing DDA Sprinkle's policies, his practice, how standard his policies or procedures are in investigating and in making decisions in the cases that he gets, and his experience and the number of times that he has done it and how he has done it and why he does what he does is very relevant for the jury to decide how to assess the testimony that he gives in terms of what he did. So it's in no way bolstering. And I believe that the case, my, bless you, my computer shut down on me and I'm getting the case that I had for the court. Okay, Brown versus State plainly says When a witness's statement does not directly address the credibility of another witness, there is no improper bolstering. When the Supreme Court evaluates whether testimony constitutes improper bolstering, the Supreme Court considers the disputed testimony in context. That's Brown versus State 302 Georgia 454, and specifically it references 24-6-620 and points out that it says the credibility of the witness shall be a matter to be determined by the trier of fact. And under that statute, a witness can never bolster the credibility of another witness as to whether the witness is telling the truth. Credibility of the witness is within the
Be sure to
province
like
of the
the
jury.
video.
And when
the
the
video,
witness's
like the
statement does
video,
not directly address the
tap on the screen
credibility of
twice.
another witness,
I
there's no
really appreciate
improper
it.
bolstering. So in our case, there is no such thing being done. In fact, the opposite is being done when with the lead detective and in the Donovan Thomas murder and with the lead detective in every other case that we have presented to the jury, the defense has constantly and consistently attempted to show to the jury that either there is a malicious or selective or somehow improper or irregular effort to target their clients. To show the absence of those very things with a witness is nothing but to have the witness show, how he is qualified to make the determinations or to do what he did, even when he is a lay witness.
All right, any argument from defense counsel?
Good morning again, Your Honor. Good morning.
Good morning.
Everyone. Your Honor,
Of course,
prosecutor
this
just
judge.
stated that there was an objection when Mr. Sprinkle was going through jail calls in which are pertinent. And I believe that we can just get there. OCGA 24-1-1 talks about the mission of a case. And here, the mission of a criminal case is whether the state of Georgia proves to the jury beyond a reasonable doubt the guilt of one or more of these accused. That's it. It's not about Mr. Sprinkle's work. And he can say, I have found this jail call. And if the court admits it, they can play it. But him going through, this is what I do, and I have grand jury power, and I don't always follow the police, and I don't indict other people in other cases at times that the police think should be indicted, is really no play here to that mission. The prosecution's attack or statement or justification maybe would be the right word that I'll just say me, but have raised the defense that the police targeted Mr. Williams. I stand by that. It came out in evidence. Just for instance, when this honorable court was here, it came out in other factions of the case before this honorable court graced the bench in this case. But Mr. Copeland's statement, which was admitted over objection on June 10th, 2015, he's with prosecutors, not prosecutors, police officers. And they specifically say, we don't want Shannon. He's a little fish. We want a big fish. And it comes out, I want Thug. I want to know where his money's from. This was embedded in the case by the prosecution. And Mr. Copeland testified, I knew who they wanted. And he said, whether it's believed or not, is up to obviously the trier of fact. But Mr. Copeland said, I knew that I can get out of that interrogation room
It
by
was already brought
finessing
in.
against Mr.
So
Williams. And I lied.
They can ride off of it like
sure, that's a
Miss
fair
Love
amount.
does all the time. So
But I was going through this last night and this morning, Your Honor. And if the district attorneys who's testifying, and he's an honorable man, if he's allowed to say what his conduct was, why he did this, why he didn't do certain things, they asked yesterday, or the court may have said,
yeah, but you attacked why some people were indicted and some people weren't indicted. I believe that came from this honorable court. Then I would like to have, I believe that's a waiver of work product. I mean, we're getting very close to strategy, and they're revealing, they being the DA's office through this witness, may be revealing to an adversary, which waives attorney work product, what they did and why they did it. And if that's true, I just know myself, and I, God willing, follow the law. I'm going to serve a subpoena. It'll be met with a quash, I'm sure, and you're going to have to go through all of the in-camera inspection of all emails, text messages, memos
Look
from
at young
meetings.
Thug with his,
I'm going to put Paul
mouth
Howard on my
covered.
witness list because this case has been languishing before indictment for approximately 7 years. And I don't
It's
see why
okay.
we're doing that, because it could extend the trial, which is fine. But it really
Like, I wonder
is
if
going to
he's
be met
cold
by a
or
blizzard
if something,
of
you know, I hope
people
nothing's happened.
reading
'cause he's
all, if you
had
allow it,
this on
of the
since
state's
they
inner
started
workings.
this morning.
So then we can confront Mr. Sprinkle. Well, you made this decision. I want to understand why you did this decision. Because this memo says this. For instance, there's no wiretap on Mr. Williams' telephone. There's a wiretap order that was given to us, a proposed order, in discovery. It was never given, that I could tell, to a court. Well, I find that interesting, but it's not in evidence. I wasn't going to ask about it. But if his strategies are coming in, he will be asked. Now, I'm confident, knowing the Honorable District Attorney elected Willis, she has control of this case. I just know that from dealings with her and in the past and on this case. So she will be added to the witness list, because it's really not Mike Sprinkle's call who to indict. That's from my experience. I'm not saying came out in evidence, but the Honorable Court knows a lot more about the inner workings potentially than I do. But we're going down such a wrong road, and the case law supports what the defense is saying. That's why we don't get into the investigation and the conduct of the investigation, but we get into the relevant information given out, unless, and it says in the rare case, R-A-R-E, rare case, that the conduct of the investigator becomes relevant. And that's all I'm trying to say. And as far as jury instructions, I believe this honorable court will be asked, whether you give it or not, it's up to the court, but there'll be an instruction. The fact that it's a party to a crime, and we have a conspiracy, so I believe it's coming. The fact that others have not been charged, are given immunity, are beyond prosecution, were prosecuted, or been acquitted is irrelevant. In the indictment itself, it states that the grand jury does hereby charge and accuse the following 28 people. And then it says, and there are others known and unknown who are co-conspirators. So there's no issue on who did you charge. Those are specific strategic decisions made by the Honorable Fani Willis et al., her office. So I am going to object to DA Sprinkle. I do believe that the state of Georgia was attempting to, probably did, say what a great job they do
I have no
by
idea
reviewing
why
all these
my
cases
light
and not letting an
is
indictment go
going,
out, which may be true.
it's
That's how
dimming,
it
and then
should be. That's
goes
what we
up and down. I'm not
demand
sure.
of our prosecutors, but it doesn't really come into this case. So I stand on our objections for the cases I gave last night.
Okay,
Hey,
yes.
Your Honor, I was just going to point out again that the way that the questions have been tailored have been in order for the jury to be allowed to see what experience Mr. Sprinkle has, what his standard operating procedure is, and to show the method and procedure by which he obtained the information that he will present to the jury.
All right, well, I gave instructions yesterday and those instructions still apply. So are we ready? I know the jury's ready. And you can go ahead and get Mr. Sprinkle back on the stand.
Can we get a Zoom link to send to Brady?
It's the same one.
No, we're trying to get.
Oh, for
Yes,
Grady,
yes. Can we get a
we
Zoom
can generate
and a
one.
time that the court will hear from the doctor?
We can generate one. Not, I mean, wouldn't it just be this? Can't we just? I mean, if not, then we'll just send another one to everybody.
Is there a time that we can
Lunch?
give to him? Okay, and that would be 12.
I mean, I don't know, maybe we need to do it at that person's convenience. Okay.
Thank you.
You can go ahead and get Mr. Sprinkle in. Thank you.
Okay, so Fani Willis has also been subpoenaed
Good
in
morning.
regards to open record.
Good
open
morning.
record law. So that must mean that she did not provide information that was requested. That's supposed to
When
be
we-
available to the public.
Broke on yesterday. I believe that the last question that I asked you was how it was that you went about targeting what phone numbers, for instance, to listen to when you are investigating or conducting an independent investigation of unindicted cases that you receive from law enforcement. Would you explain to the jury how you go about doing that?
Well,
I think he already answered that question yesterday.
I think that there was the objection posed at the end of the day. So I think that was, he had not completed his response.
My understanding is that he did, and so I'm going to object on asked and answered.
Your Honor,
Sustained.
Mr. Sprinkle, where is it that you get the information from regarding what numbers to look for in Securus as you began to look into how to make your decisions in investigating independently cases that you receive?
well, there's a few areas. The first is looking at the numbers that the inmate called and running each number individually to see which numbers the inmate actually called versus which numbers another inmate called using that inmate's pen. That's the primary way.
If you slow down just a little bit.
All right.
Go ahead.
But the other way is I would, if I had, for example, from intelligence that's gathered during the investigation, for example, if cell phone records were obtained by the investigator or by me, however they were obtained, I'll go through, for one of the parties involved in the case, I'll go through them and I'll generate a list of phone numbers from those phone records. And what I'm trying to do there is run every phone number that occurs in a party of interest phone records through the jail call system. Because I'm not oftentimes just looking for phone calls from people that have been actually charged with the crime. I'm also looking for phone calls from people that may know something about the crime, and that those phone calls are placed to those people in close temporal proximity to the homicide or event that I'm interested in.
And how, when you
Do you
speak
hear
about
that?
the fact that
Pay
there are
attention,
some
folks,
calls that are
to
made
this
off
trial,
and some calls
just
that
for
are
the
not.
sake of even
How do
having
you
knowledge
determine
about
when a
how
call is
they
made
go
by a
after people and
person
how
that
they
you
get
are
information.
actually seeking to
Listen
gain
to what this man
information
is
from?
saying.
There's a number of factors that go into that. One of the most basic and easiest to explain would be I just recognize the voice. If we're talking about the inmate, like if I want to verify that it is in fact an inmate that I'm interested in that's placing the call, then I just develop a familiarity with their voice through various means. Wherever I can find a known exemplar of their voice, then I listen to that and I learn their accent and the tone and tenor of their voice. And that based on a few other things, like, for example, how often the inmate customarily calls this number. If I know that that number belongs to somebody that's a close family member or friend of the inmate, then that's another thing that is kind of an indicia of reliability that is in fact the inmate that's calling that number. But I think the primary thing is just knowing their voice.
Is it a common practice to, once you have done these things that you've described for the jury, for you to then talk to people that have not been identified?
I couldn't hear what you said, because y'all were both saying something at the same time. Objection, what?
Leading, Your Honor.
Overruled.
Is it a common practice for you, once you have done all these things that you have described for the jury, for you to talk to people or endeavor to talk to people that have not previously been a part of the case file?
Yes.
Well, Mr. Adams,
Now, when
I'm
you do
assuming
that,
he's gonna
is
be
that something you do
cross-examining
alone, or do you do it with the
Mr.
lead
Sprinkle, this
detective
DA.
or your investigator? Or
And
a
with his
combination?
objection so
A
far,
combination.
I cannot wait, because
How often is
evidently
it
this is a
that you
vital
have
piece of
actually
information that the
found
state is
people that
needing from
you
this DA. So
had not previously identified is a part of the case file, that were people you sought to obtain
that's how you can kind
information
of tell.
from to further investigate a case?
I'm going to object as to
often is it?
relevance, Your Honor.
That's how you can tell what, see that? That's how you can tell that a witness is something that they're testifying to or that they're saying is important for the state. When you hear a lot of objections, so just a little pointer there to give to you in the event you're watching and you're wondering, some people that's gone up here, you haven't heard any objections. Miss Love has the same form of questioning, but some witnesses, they're not giving that vital information that is important to them, as important.
Sustained.
When you actually do locate a person and go and talk to them, do you put that in some kind of memorandum or recording that you preserve to provide to the defense?
Generally, if not invariably and always, I at the very least record the interview unless it occurred in such a circumstance where that was not possible, such as at random and it was unplanned. But if it's an interview where that I'm actually planning, then I would audio record the interview, unless I don't believe I've ever actually had an occasion where the audio recorder failed. So I wouldn't even say barring the unforeseen, like the audio recorder failing. So yes, I would always record it.
And do you also provide supplements to the case file that you receive from the police?
Yeah, not in every case, but particularly if it was a case in which I did a lot of extra investigation, then I would write a supplement usually.
When do you do what you just described or called extra investigation? In what circumstances would you do what you call extra investigation?
Well, if it was,
And you can explain to me.
In my estimation, if the case needed more investigation, if it needed extra investigation, if after reviewing the case file, I found that the evidence was lacking and that it wouldn't be appropriate to present the case to a grand jury, let alone take it to trial, then I will conduct a quote unquote extra investigation, as I called it, hoping to find more evidence to make the case better or otherwise dispose of the case appropriately.
Now, let me ask you this. What about people that have already been interviewed by law enforcement? Do you ever go out and interview those persons after receiving a case file?
Your Honor, I'm going to object again as to relevance.
Let's go ahead and move on to more targeted questions, please.
When you receive a statement of a purported witness in a case, do you take the statement given to you in the case file as all that that witness has to say, or do you ever endeavor to
I'm
go
gonna
speak
object to
with them
leading, Your Honor.
yourself?
Sustained.
Do you do anything with the witness statements that you receive in your unindicted cases that you get from law enforcement?
Objection, relevance.
Your Honor, that goes directly to his practice, his way of conducting investigations into the cases that he then makes other decisions for, and it goes to how it allows the jury to gauge his practice, his
Counsel approach, please.
So this is pretty much, in my opinion, Miss Love's way of trying to force in what she wants. Alex, stop. That's my dog. Okay, so now I'm jumping all over the place with things that I'm talking about, but back to Fanny with her Fanny. This is what Superior Court Judge Rachel Krause said. Was it yesterday? Okay, she said, unless and until Miss Willis is called to the stand and refuses or fails to appear, if ordered to do so, she's not in contempt. And so that motion is premature. Okay, so that's so the laws might be subject to a subpoena. Oh, this is in regards to. Okay, so it appears that there's two different. Yeah, so I'm looking at. Um, so there's the misappropriation of funds that Fanny's involved in, as far as her hearings. There's the Donald Trump RICO case. And then there's the open records violation that's been filed against her as well. So from my understanding, there's three different cases that's going on. That she's involved in. Okay.
DDA Sprinkle. Did you work with Detective Thorpe on the case involving the murder of Donovan Thomas Jr.?
I did.
And in working with Detective Thorpe, do you recall when it was that you received the police file from the Atlanta Police Department?
It would have been late 2015 or in early 2016.
Did you document when you received the case file from Detective Thorpe in a memorandum or report that you provided as part of the case file?
Yeah, it'd probably be this report.
Don't hold it up. Don't hold it up.
Well, anyway, this report right here that I brought to the stand, the 140-page one.
140 pages?
Yeah, I believe that's how many pages it is.
Okay.
Yep, 140 pages.
And would you look at that if you need to refresh your memory about when it was that you received the case file from the Atlanta Police Department?
Yeah, right here. In fact, January 2016, it's the first four words of the report.
All right. Once you received the case file from Detective Thorpe, without going into what was said by this person, did you notice a witness or identify a witness that you wanted to speak with further?
I did.
Who was that person?
Spencer Wright, AKA Nicholas Robinson.
All right. Now, Spencer Wright or Nicholas Robinson, first of all, why are you saying AKA Nicholas Robinson?
Because
Intelligent.
well, that was a name he provided contemporaneously with an October or a September 2015 arrest, I believe.
Of himself or someone else?
Of himself.
All right. And is that person a person who had a statement already inside the case file you received from the Atlanta Police Department?
He did.
All right. So if there was a statement by that person already inside the case file, why did you want to speak with that person? Or did you want to speak with that person again?
I follow-up questions.
Say that again?
I had more questions, follow-up questions, other questions that after reviewing the case file that I had, that hadn't been previously asked by the Atlanta Police Department.
And is it common when you have questions that haven't been answered in your regular course of reviewing cases to locate those persons, to ask them more questions?
Yes.
Objection, relevance.
Overruled.
How did you locate Spencer Robinson, AKA Nicholas Wright?
Spencer Wright was an
Spencer
Pay
Wright,
attention
who
to this
is,
DA. He is
What,
so,
Spencer Wright
the
was
one
an inmate
that's
at the
on the
Atlanta
stand,
City
he is
Jail,
very
located
quick to
next door to the Public
answer,
Safety
Ms. Love,
Headquarters at 226 Peachtree Street,
and
which
I
is like
think
2
he's
blocks
doing
away.
that for the fact
how
that
did you
I'm
find out that that's
objecting
what he was?
quite a bit. So he's trying to answer the
Well,
questions
I don't
before,
recall exactly.
get
I
out what
knew
he
that
has
that's
to
where they
say
housed him
before
after he was
Adams can
arrested in
object.
October of 2015. Somebody told me, I'm sure that that's where he was, or my investigator found that's where he was. At any rate, that's where he was when I wanted to interview him.
Now, at the time that you received the case file from Detective Thorpe, had there been arrest warrants taken out for individuals?
Yes.
Who were the arrest warrants taken out for at the time that you received the case file?
Kenneth Copeland, Antonio Sledge, Demikian Garlington, and Shannon Jackson.
Shannon Jackson, does he have any other name?
Shannon Stillwell.
And when you received the case file, did the case file have in it more than a written report? In other words, did it consist of audio interviews, surveillance, anything like that?
It has surveillance video, had a written report drafted by the lead detective, among other things. But the key things were the written report drafted by Detective Jim Thorpe Jr. of the Atlanta Police Department, the surveillance video that depicted the incident, another surveillance video from a gas station. I believe I had that in the initial case file as well. Some crime scene photos, I believe, may have been in there. Although I do recall obtaining more some point later, but and audio from interviews, some cell phone records. I don't recall every single thing that I had. I didn't obtain the entire case file immediately because I recalled throughout the course of my work on this case, consulting with other investigators with ABD and obtaining little pieces of the case file as I went along. But
Hold on, stop.
yeah.
All right. So, would you back up, and I'll use one of my colleagues' words, and unpack what you just said a little bit for the jury?
Regarding the murder of Donovan Thomas, I had audio interviews from some of the people that, if not all of them, that Detective Thorpe interviewed as part of his investigation and his report, and surveillance video.
All right. And so slowing down a little bit, you said you did not have all of the case file, that you got other information from other investigators?
Well, I guess it's how you define case file. I had what Detective Thorpe provided me.
Okay.
But there were other investigators at APD that had been working on this matter. And so
And were those other investigators, the information you sought to get from them, were they not in or part of the file Detective Thorpe gave to you?
right, I remember in particular, there was a lot of cell phone records that I obtained from another investigator that I did not obtain from Detective Thorpe. And that if specifically when I say another investigator, I'm talking about Tyrone Dennis.
Okay. Now, if you would, slowing down a little bit more, if you would, please tell the jury how you determined that Detective Dennis had information of interest to you in this case.
Well, I met with Detective Dennis sometime in, I believe it would have been January 2016, sometime in early 2016.
Did you meet with him with Detective Thorpe?
No, I believe it was Detective Dennis and Lakia Gaither, and I met them at the Atlanta Police Department's Public Safety Headquarters in a large conference room.
Okay, pause. So when you first got this particular case with the individuals listed that you just named, for whom warrants had been taken out, did you follow the same procedure that you described yesterday for the jury to gain additional information
Yes,
in order to assess the case?
yes.
Was there anything that you knew personally about any of the people for whom warrants have been taken that made you decide to go out and seek additional information in this case?
Are you asking me, do I personally know the defendants, the people that the police charged?
Yes.
No, I did not know them.
Did you have, did you know when you got the case file, when it was that Detective Thorpe had talked to Spencer Wright?
It would have been in October of 2015 on the night of his arrest.
And did you have, as part of your case file, information that immediately after talking to Spencer Wright or Nicholas Robinson, that Detective Thorpe took out the warrants for the persons you just named?
So Spencer Wright was arrested on October 19th, 2015, the same being the night that Detective Thorpe, among others, interviewed him. And the warrants, and please correct me if I'm wrong, but I don't think I am, were taken out October 20th, 2015. For the 4 defendants that I referenced earlier for the murder charges.
Where did you have surveillance video from in the file that Detective Thorpe gave you?
So there was a surveillance, from what I recall, 2 surveillance cameras mounted on the barbershop located at 330 McDaniel Street. And then you went about maybe 100 or 100, maybe not even 100 yards away. There's a gravel lot and then a street. There's a Texaco station, McDaniel and Northside Drive. And I had surveillance images from that station.
Were you personally familiar with that location? Have you gone out and personally seen it?
Yes, I've been to that location before, yes.
After you got Detective Thorpe's file, did you find yourself out there again, or did you go use what you had to make any kind of determinations?
Yeah, I drove by there a couple of times, a few times, as I looked over the case just to get the lay of the land, because you can only see so much from Google Earth.
All right, so backing up, when you say you drove by there a couple of times, did you just like drive down the street, or did you stop? What did you do?
I drove down the street, I would stop, and I would just take a look at the lot just to get a kind of, rather than the 2D perspective that you would get on, like I said, Google Earth. I wanted to just kind of see where all the buildings were situated and that kind of thing. I mean, I didn't get out and like linger around, get out of my car and like linger around or anything like that. I didn't really see any reason to do that. But yeah, I did like survey the crime scene.
Why did you do that? Why did you go out there if you already had the surveillance footage?
Again, just to, because it's one thing to look at a scene on a screen, where you can get some 3-dimensional perspective from the images. It's quite another to actually be at the scene and not be staring at it in 2 dimensions from a computer screen. You know, you get to see, you know, where somebody's view would be obstructed depending on where they were standing and that kind of thing.
Is that the only thing that you get of value by going out to a scene after you get a police file? Like where somebody's view would be obstructed, you're allowed to tell the jury what value you gained from going out to the scene.
Well, I mean, it's just important to see where the crime actually occurred. Sometimes, particularly if it's like in an apartment complex, you know, going out to the scene, you can do a witness canvas, start knocking on doors.
Did you do that? Have you done that?
I have. I didn't do it in this case because this occurred on a public thoroughfare.
Okay.
But yeah, anywhere where there's a homicide, where there's a lot of people, like pretty much an apartment complex or a neighborhood, I found that can be beneficial.
All right. Did you also mention Google Earth earlier?
I did.
Why did you mention Google Earth?
Well, Google Earth, in this specific case, I went to Google Earth because I did eventually end up interviewing Spencer Wright myself.
Without talking about what he said.
Right. And right. Well, I'm not even going to get into what he said. I just went to Google Earth to create, to take still shots of images that were photographed by those Google Earth vehicles, I guess, just so I could show them to him and say, okay, well, where were you at this time when you said you saw this, et cetera?
And had he said those things previously in his interview with Detective Thorpe? Had he given the information of where you were at this particular time?
He
Without saying where he was, had he given that?
he offered a verbal description of where he was.
Did you capture whatever it was that he said verbally in the Google Earth photos that you then chose to show to him?
Objection, Your Honor, hearsay.
Objection, what?
Hearsay, Your Honor.
Overruled.
After listening to Detective Thorpe's interview with Spencer Wright, did you attempt to find on Google Earth where it was that he was located?
I did.
Were you able to locate an area that coincided with or matched the area he described being in?
Your Honor, I'm going to object to any reference to statements made by this witness who's not testifying as hearsay.
Your Honor, this witness is not going to tell the jury. First of all, we're not offering it for the truth of the matter asserted. We're offering it to
Shoot, my spinach was all the way at the
allow
bottom
jury
of
to
this
see
movie.
what Mr. Sprinkle did in context. He located a certain area.
Let's not say what he did. We need to hear that from the witness.
Okay, so it's provided.
Overruled.
Thank you.
It's the healthiest part.
So were you able to see that area described by Mr. Wright on Google Maps?
Yeah, I found
Coincided.
I found an area that I believed he described. Yes.
Why were you looking for the area where Mr. Wright described?
Well, specifically, because the area that I believed he described was also captured by the surveillance camera that captured the incident.
Okay.
So if Mr. Wright was where I believed he was based on what he said, then it would be in the surveillance footage. I would see him, or a human-like figure. Given the clarity of the surveillance footage, it wouldn't have been sufficient to actually make out his face, but I would have at least expected to see that.
Did you see Mr. Wright or a human-like figure in that area you were looking at on the surveillance footage?
I did not.
Did you fully capture that area on the still shots that you took down to show to Mr. Wright?
I did.
When did you meet with Mr. Wright?
This would have been January 12th of 2016,
Where did you meet with Mr. Wright?
the
Fall
Atlanta
asleep
City Jail.
here.
Now, was Mr. Wright being
Hey, you
held
heard me.
on felony or
I'm
misdemeanor
gonna fall
charges?
asleep over here.
It's a probation violation on a felony case.
Now, did you offer anything to Mr. Wright in exchange for him speaking with you?
I didn't.
Had, to your knowledge, anything been offered to Mr. Wright by your office in exchange for him speaking with you?
Not to my knowledge.
Was there any insinuation that you would lower his charges or drop his probation warrants?
Not by me.
Was there any made by anyone associated with you that you have any knowledge of?
No, not to my knowledge. I have absolutely no information to indicate that that ever happened.
Kareen, how you doing this morning?
Who went with you when you talked?
As you
to
come
Mr.
in,
Wright?
be sure
The
to
aforementioned,
like the
the
video
investigator I mentioned yesterday, David
and
White.
definitely comment if you guys, have something to say.
Do you remember how long you met with Mr. Wright?
Probably maybe like an hour. I audio recorded it, so however long the audio recording is how long I met with him. Well, for in relevant part, and I audio recorded the entire thing. It would probably 45 minutes to an hour and a half. I would expect somewhere in there.
Did you video record it as well?
I did not. In fact, I brought a voice recorder no, I just brought a pocket voice recorder.
Now, why weren't you in an interview room, video recording you all's interaction?
It was actually in a pod, like an inmate dorm at the Atlanta City Jail where Investigator White and I interviewed him. And there's like a little, like a break-off room to the side of the pod, and we just met him in there. There was a table and chairs in there, and we just talked to him.
And were any other inmates around while you talked to him? Present?
Well, they weren't in the room with us. I don't recall if they were out and about in the dorm. But yeah, there were other inmates. I don't recall that any of them were within earshot of us, though.
Not within earshot. Is that what you said?
I don't know. Certainly nothing happened during the interview that alerted me that somebody was listening in. I'll leave it at that. And I don't recall having a feeling at the time that, because I believe I would have. That would have left an impression on me if I thought that others were eavesdropping. And I didn't have any
Yeah, I think we're gonna
feelings
try
of that sort while I was
let's
doing the
fast forward
interview.
a little through this.
Now, to have been at.
Yes, he did.
Were you interested in looking at a particular time on the surveillance footage after listening to Mr. Wright's interview and speaking with him yourself?
I was.
And what particular time were you interested in looking at?
Well, time is in a constant here because there's the time that I believe the incident happened, and then there's the timestamp on the video, which differed.
Okay. And so let's start with the time that the incident happened. If it's different than the time on the video, how do you go about finding what time to look at?
Well, I'm watching the video. If you, in this case, you have a surveillance video, and the incident of which we're speaking is prominently featured when you watch that video. So I could just watch the video and wait for that incident to occur, and that's when I knew that the portion of the video that I was viewing was relevant insofar as it depicted the incident, regardless of the timestamp emblazoned thereon.
And during that time that you're looking at the video, are you able to discern where that bench at the bus stop is in relation to where the shooting occurred?
Like it was about, like I said, across the street, not directly across the street, but probably across the street and maybe 20 to 30 yards to the right if you're facing across the street from the barbershop.
Did Mr. Wright recognize the bench in the surveillance footage, or were you able to show him the bench in the surveillance footage?
In your honor, calls for hearsay and also confrontation clause.
Sustained.
I would withdraw that. Did you ever see Mr. Wright in any part of the surveillance footage of the murder, or someone fitting his description anywhere near that bench? And by anywhere near, I mean sitting on or within 1 foot of the bench during the time of the murder?
No, there were no human-like figures around the bench. I saw a cat at one point.
You saw what?
It looked to be a cat.
A cat. You could see a cat on the surveillance video?
Yeah, that's what struck me. It wasn't real high fidelity, but it was, the light was bright enough and the fidelity was sufficient to see a feline moseying around the bench, but there was unambiguously, there were no people around the bench.
Did you check the surveillance maybe like a few minutes or minutes after and minutes before the murder, just to see if perhaps there was a human at that bench?
Oh yeah, I'm sure I did. I watched that footage many, many times. Of course, the most relevant period to me was the time when the incident actually occurred. But no, I didn't see a human at that bench.
And how many times did you watch that video?
I didn't keep count, but it would have been many, 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 many times. So at least 150 to, I don't know. It was many times.
Why did you watch the video so many times?
to see every time every time I watched, I was hoping to see something maybe I hadn't noticed before, the way the light bounces off one of the vehicles, because that was a big part for me. I wanted to figure out what sort of vehicles we were dealing with here. I actually had the video enhanced at one point because like I said, the video wasn't very high quality. So yeah, I had to kind of try to fill in the blanks myself. That's why I viewed it so many times. And also just I always would hope, a lot of times it would probably just be in futility, but I would always hope to see something I hadn't seen before.
Now, when you said you had the video enhanced,
Boy,
did you tell
Merchant
the
is
jury
not playing with Fannie
what you
Willis.
mean? I mean, when you
Ashley
say-
Merchant has it in
I sent it off to
for
private
Fannie Willis.
corporate companies or individual. There were two. It was
I
Target,
think
like
that's
the
probably the only
retail
person that
store.
I've heard of
They have
that
a
I've noticed
division
so
within their
far
company that deals
that
with
is not
surveillance
afraid of
footage.
Fannie
And
Willis.
they at the time, maybe they still do, but they at the time, they would digitally enhance surveillance videos. And there was another gentleman named Walter Pineda who offered the same services. He was an individual.
Why did you send it out to two different places?
Just, I guess the more the better.
Were those, either of those places able to allow you to see anything more clearly in the video?
A little bit. Yeah, it helped a little bit. Yeah, it's digital. And I'm buying, so there's really only so much they can do to clean it up. It's just ones and zeros, but they are programs that can, I guess, kind of filter out some of the noise from the picture and that kind of thing. And that's what they did. So it helped a little bit.
Now, is it unusual for you to take surveillance footage in unindicted cases you receive from law enforcement officers and send it out to other agencies to have it, to see if you could have it enhanced at all?
Objection, Your Honor, relevance.
Ever ruled?
It is actually, I think this is the only case I've ever actually done that on,
And why then did you choose to do it on this case?
because the video was so important and I really needed to identify as much as I could in that video.
Now, was this, when you say the video was so important, was this particular homicide case for you any more important than the others or any others that you worked on, the case itself?
No, it wasn't any more important. Any case, it got more attention because for my purposes, it was essentially unsolved right when I got it. And so that elevates the priority of any homicide case. Now, I wouldn't say priority isn't the right word. It really isn't. It's just the amount of time that I'm going to spend on it certainly goes way up.
Okay. And when you said it got more attention because it was unsolved, how often did you get unsolved cases in your capacity as an unindicted homicide?
Objection, relevance.
Overruled.
Not very often, thankfully. The police don't normally make charges on.
Relevance and non-responsive.
Sustained,
So,
sustained.
all right, when you say not often, can you tell the jury approximately how many unsolved homicide cases you worked with during your time? And it doesn't have to be an exact number, just approximately. Because my follow-up question is gonna rely on.
Maybe 20 to 30 truly unsolved cases.
In those other 20 to 30 cases, did you perform acts or investigations in the same manner that you performed your investigation or further investigation of this particular case?
I did.
And did that include seeking out witnesses that had not previously been identified?
That is correct.
Did that also include finding jail calls
It
that
did.
had not been identified?
It did.
Did it include going out to scenes?
It did.
Did it include interviewing people who had already been interviewed?
It did.
And do you, with those other cases, did you include as part of the case file, recordings that you conducted, recordings of persons that you conducted interviews with?
Yes,
And did you include any cell phone data, jail calls, social media, things of that nature that you found during your independent investigation of the case?
I did.
And after you got the video enhanced of the barbershop, did you review any other, or I should say, did you review any other video besides the barbershop video?
I did. There was that video from the Texaco station. I reviewed that.
The video from the Texaco station, were you familiar with how to work that system when you first got it?
Well, I didn't, when you say system, I didn't receive the original recording apparatus.
Okay.
But the software, yes. Yes, I mean, I figured it out and was able to view the video.
When you first got that video, was the timestamp on that video the same? In other words, was the time on that video the same or different than the time on the barbershop video?
From what I recall, the barbershop surveillance video is considerably more accurate than the video from, or excuse me, the Texaco station video is considerably more accurate than the barbershop video, if not entirely accurate.
Okay. So if it was different, how were you able to look at the Texaco video and determine
so I'm just
anything as it
gonna-
relates to what was happening in the barbershop?
So the frames enter,
I'll be right
there
back.
are certain parts of the frames that overlapped. So in other words, so you had a camera at the barber shop that was capturing the street, and then you had a camera mounted over at the Texaco that was also capturing that same street, and the two cameras were capturing part of the same part of the street. So if I saw something happening in one frame, I could just marry it up to the from the image caught by the other camera. And if I had, for example, and that's how I would be able to tell. So in other words, I wasn't using the timestamp, particularly in the barbershop, since the timestamp was wonky. But even if the timestamp looks correct, it could still be a few seconds off, you know. So I was mostly things that were constants to me were like vehicles driving by the scene or when gunshots ring out. You know, I would look for that. So so on the Texaco footage, I don't recall exactly. There was a blue car that came into the gas station. There was something that was captured on both cameras that I was able to use as a marking point to sync up the two pieces of footage.
Okay. When you were reviewing the Texaco footage, did you only look at the time frame that you thought that the murder occurred?
No, I particularly as I continued my review, I looked at probably like 30 or 40 minutes before the murder occurred. I looked at the entire piece of footage.
We're gonna come back to the Texaco footage, but I wanna ask you, after looking at the Texaco footage, did you do anything to identify persons or objects that you saw in the Texaco?
I did.
Would you tell the jury how you went about identifying certain persons and objects? If you need me to clarify, ask me to clarify.
Well, there was, and without getting into, all right. So there was an event that occurred on the video. First thing is that I was looking for something specifically that, based on other evidence in the case, I'll just keep it broad or general here. Based on other evidence of the case, I suspected I was going to see on the video. And then as I watched the video during that time frame, I did in fact see what I thought I was going to see.
Did or did not?
I did.
Okay.
And it was a vehicle specifically. There was a certain vehicle, and when I saw it, based on other things that I had seen, and specifically I'm talking about social media records, photos, and cell phone tower data, I thought I wonder if this person is at the gas station. And when I looked at the footage, I said, oh, well, I recognize that vehicle from social media. And then as I continued to watch the footage, I recognized one of the people that was inside. It was a passenger in that vehicle because that person walked into the store and they got close to the camera. And because they were close to an interior surveillance camera in a well-lit store, I was able to see their face. And then as other things happened around this vehicle that I recognized in the footage, I complete investigative tasks to figure out who the other people were. I already knew who one of the people was, the person that was driving the vehicle, or I had a strong suspicion as to who was driving the vehicle I was looking for based on cell phone records and social media photos and videos. So I already knew right when I saw it. I had a pretty good idea. I knew for a fact who one of the person was, and the person that was driving the vehicle, I had a pretty good idea who it was.
All right, let's unpack a little bit of that. Now, what vehicle were you looking for?
It was a 2002 Pontiac Bonneville,
What color?
gray.
Why were you looking for, better yet, did you have a particular reason for seeking out that vehicle?
Your Honor, calls for hearsay.
I haven't asked him what anybody said.
I don't know what the answer's gonna be, but it potentially could.
Let me tighten it up then. Was there a particular person of interest to you based on what you had learned during your investigation up to that point?
Objection, called for hearsay.
Sustained.
Were you looking for any particular gray Pontiac Bonneville?
There was one particular gray Pontiac Bonneville that I was interested in. Yes.
All right. And who did that Pontiac Bonneville belong to?
It either belonged to or is associated with a man named Javoris Bradford.
Is there a nickname for Javaris Bradford?
Tuda, Tuda.
All right. Now, did you attempt to locate any social media footage that related to Javaris Bradford or Tuda?
I did.
Would you please turn to the jury and tell the jury how you went about locating social media accounts associated with Javaris Bradford or Tuda?
Well, I just searched for him probably on Facebook first, because particularly back then it was easier. And I either found him or a family member on Facebook, and then browsing the family member's profile. And this may not be exactly how I did it, because I don't recall exactly how I found Mr. Bradford's Instagram page. But somehow or another because on Instagram, he went by the moniker I'm_living_great at the time.
Mm-hmm.
And so basically on probably starting at Facebook, finding family members, fanning out, and then on finding him on Facebook, finding maybe where he screenshot an Instagram page and pasted it to his Facebook. That would be how I would have found his Instagram page somehow. And then, and like I said, his Instagram name was I'm_living_great.
And did he have himself depicted in that Instagram footage?
I'm gonna object, that's hearsay.
Overruled.
What did he have himself depicted in that social media footage or social media information that you saw with any kind of vehicle in particular?
Yes, it was a 2002 Pontiac Bonneville.
Gray?
It was.
Okay. Did you ever discern or gain a number for Tuda? Did you ever learn of a phone number for Tuda?
I did pretty early on, actually.
Where did you get the phone number from for Tuda?
So I testified previously about how I.
But don't talk about your previous testimony. Have you ever testified in front of this jury?
Yes, yeah, that was something I said like earlier today.
Okay. So without referring to the fact that you previously testified, just tell the jury.
No, I'm talking about like previous testimony, like a few minutes ago.
Okay, go ahead. tell the jury.
All right. So one of the ways I find jail calls is I go through phone records that I had in the case. And in this case, I had some phone records.
All right.
And I don't recall whose phone records it was exactly. But I just started running numbers from that appeared in the phone records, whether they be called numbers that were called by the handset, the records of which I was reviewing, or numbers that called that handset. It didn't matter to me, just whatever. I was running them through the jail call database. And one of those, because like I said, I was trying to get intel. It wasn't just, obviously on the night of the shooting, the murder. Yeah, I mean, I would expect that the people that committed weren't in the Fulton County Jail. So I obviously wasn't looking for inmates to be saying that they did it.
Okay.
But I was trying to get for intel from people that maybe were being called from inmates. And one of those numbers was 404-957-8008. And I'm flipping through these discs to make sure to refresh my recollection.
Okay.
To make sure that I'm citing that. Yes, that is right. 404-957-8008 was one of the numbers that appeared in those phone records and that I ran through the jail call database. And on doing so, I did find calls that I deemed relevant that were placed on the night of the homicide from an inmate inside the jail.
So, Madam Court Reporter, and I suspect some of the jurors have informed me that you are speaking a little too fast. Do you mind slowing down and saying what you just said one more time?
Yes, I found a number inside within the phone call logs that were obtained by the Atlanta Police Department for one of the parties of interest, whether it be a person of interest or a witness or a defendant, whoever it may have been. And it didn't matter to me. All I wanted were numbers from the phone numbers of people that may have known something about the homicide and may have been called either on the night of the murder, the day after the murder, 2 days after the murder, whenever they were called.
You're getting really fast again. With
All
the
right.
way you're talking, so try to slow down.
All right. And one of those numbers of the many that I ran was 404-957-8008. I ran it through the jail call database and I found that there were 2 calls I was able to retrieve anyway. I think at least 2
Okay.
that were placed to that number on the night of the murder from an inmate inside the Fulton County Jail. And they were placed after the 8:00 p.m. hour. I think they're maybe between 8 and 9 p.m. that evening.
Young person.
Why did
It's a
that
courtroom. The court
particular
reporter
piece of
is supposed to be able to
information have any
be a little
value
more
to your
skilled.
investigation?
What piece of
Then-
information exactly?
That there were 2 calls made to that number by
us
an
regular
inmate at the
folks.
jail
So
on the night of the murder, around 8.
I'm
or
assuming
at the
that's
time you
why.
testified.
Well, I listened to the calls and it sounded to me like they were talking about the homicide.
All right. So were you able to identify who it was that was inside the jail that was making the call to that number?
I did.
How did you identify who it was inside the jail making the call to 404-957-8008?
Well, I believe, would you like me to say the name?
Well, number one, I would at some point, but hold on before you do. And let me ask you this. If you need to refresh your memory with any part of your report, would you just alert us that you're doing so and go ahead and read whatever you need to read?
Okay.
Do you need to refresh your memory at all?
No.
Okay. How did you learn the name of the person inside the jail?
It was placed from the account of the inmate.
Okay. And how were you able to determine that the persons whose name was on the account is the actual person who's making the call?
Well, I gained familiarity with his voice by listening to other phone calls that the inmate made with persons that were well known to him. And then I later confirmed it by just like listening to the call with the inmate.
Okay.
He affirmed it.
All right. So tell the jury who it was that was inside the jail.
Martinez Arnold,
And does Martinez Arnold, to your knowledge, go by any other name?
Duke.
All right. At the time that Martinez Arnold was inside the jail, and what date was that you are talking about? January?
It was January 10th, the phone call. It was January 10th, 2015.
During that time, do you have any information about what color Mr. Martinez Arnold's hair may have been?
At the time that he placed the phone call?
No, during
Don't come
around
over
the
here,
time of
Alice.
early
No, no, no. Go
2015.
back.
Do you
Stay
know
where,
whether or
no.
not, if
Alice,
you
my
don't, that's
dog.
fine. You know anything about color of his hair?
No.
All right.
Come on.
So once you listened to calls, did you attempt to get any more calls made from the Fulton County Jail?
I did. I downloaded a lot of jail calls on this case.
What jail calls, how did you go about deciding which jail calls in this case you were gonna download?
Well, I tend to be I'll download because the jail calls don't reside on the server, the Securus Corporation server forever. I try to err on the side of just downloading them. So as I ran those numbers through the Fulton County Jails database, any calls that came back on the numbers from this phone, like the phone records, I just download them. But what would prompt me to pay particular attention to them is if they were placed in close temporal proximity to the homicide. Certainly a call placed like an hour or two after the homicide would be something I'd want to listen to. Also, I downloaded calls of the defendants that they placed following their arrests at the Fulton County Jail. I put those in the file as well.
And at the time that you were looking for the phone number and confirming, you picked up something in front of you. What is it that you have on this stack of items in front of you?
Those are just, I burned all of the jail calls. Not every single jail call that I download during but most of, I tried to confine or memorialize as much as I could to this report that I testified about earlier today. It's 140 pages long. And as I went through the report.
The answer is non-responsive to the question.
Listen to the question and try to focus on answering the question that's asked.
I'm also going to object to the relevance of the length of his report.
Sustained.
What is it that those are in front of you?
They're just the jail calls that I testified to downloading and interviews that I conducted. I burned them to disk.
And the one that you picked up, to refresh your memory about the 404-957-8008, would you pick that up?
Okay. Here we go.
I'm going to show you.
This dog is determined to get over here. She's all on this side. Oh, goodness.
What I have now
Just in case.
labeled as 500 wide.
Mhm.
That's the disc that you just handed.
Yeah, yes, this is a disc that I created yesterday.
Okay.
That's my handwriting, and in fact, I signed the disc, my signature.
Okay.
This is a disc that contains the jail calls to 404-957-8008 that I downloaded.
Now, when you said that you downloaded it yesterday, do you keep all of the jail calls that you download in a particular case somewhere where you can later copy it to a disk, or what?
They're on a server. My case file, all the case files are on a server. They're all digital. They're just stored on a computer.
Okay. Had the name that you received from Detective Thorpe?
No.
And do you recall approximately how long after you received the case file from Detective Thorpe that you became interested in the name Jabari?
It would have been on or around January 10th, 2016, when I found the jail calls that are on State's Exhibit 5004.
I think that's 500Y.
Oh, 500. Excuse me. All right.
Thank you, Judge. I'm sorry, I'm sorry. Terrible handwriting. What about the name Martinez Arnold? Did you know about that name? Was that name in Detective Thorpe's case file that he gave to you?
That I don't recall. I don't know that I don't recall if he was in the case file or
And
not.
let me ask a better question. At the time you received the case file from Detective Thorpe, was the name Martinez Arnold of any interest to you in this investigation?
I don't recall.
Did you note anywhere in your report whether or not it was?
I'm sure I referenced him in my report.
I bet
insofar
you
as
guys
the
are like,
inmate that placed
okay,
the call that
she's
became of
got the
interest to me,
dog
but as far, I'll
paws
just say this,
walking
he
on
was
the
in jail on the night
hardwood
of the
floor.
murder.
You can hear that. And then my slurping of my coffee. Those both are
Before
irritating
downloading those
sounds.
calls, did you know he was in jail on the night of the murder?
I don't know if I knew or not.
Okay. After you downloaded those calls from the night of the murder, did you find any other numbers of interest to you in this investigation?
Numbers,
Phone numbers. Did you find or locate any other phone numbers or persons that were of interest to you?
yes.
What phone numbers did you find?
Well, yeah, I get, there was a number, there was a lot of, I mean, I remember doing quite a few, search warrants for cell phone numbers and focusing on cell phone numbers or records that had been, obtained by the police department.
Okay. So going back to the way you described obtaining information to conduct more investigations, did you follow the practice that you ordinarily follow in terms of search warrants to get more information, to gather or follow up on information you learned?
I'm gonna try
Yes.
something.
With respect to Spencer Wright, did you ever see any jail calls from him?
I did.
All right. Now, where did you look to find jail calls from?
For Spencer Wright?
Yes.
Well, I wasn't able to look for the jail calls myself for him. They were on a different system because he was at the Atlanta City Jail. So I reached out to someone there and asked them to pull them for me.
So thank you for clarifying that. Is reaching out to someone at a different facility with access to calls you don't have access to something that you did only in this case? Or is that a practice that you, is that a practice you follow to get information?
No, I've done that on other cases. That's not uncommon.
And if you slow down and speak into the mic and to the jury, say that.
Yeah, yes, I've reached out to other facilities, jails and prisons, correctional facilities in the past to obtain calls, recorded calls placed by the inmates that I don't have direct access by way of a login and password at some website.
Okay. And so when you reached out to the Atlanta City Jail, what information were you trying to get if you didn't know or have Spencer Wright's jail calls or phone number? What were you trying to get?
I just wanted to see what Spencer Wright, I wanted to hear, I should say, what Spencer Wright was saying to people after his arrest in October of 2015.
And did you ask for a specific time frame of calls or just all the calls? What did you ask?
From what I recall, I asked for all the calls that had been made from his account since his the beginning of his incarceration at the Atlanta City Jail, and then I believe I also had a few phone numbers that I wanted to run, that I asked them to run queries specifically in the event that he utilized another inmate's account to call that number.
So that's interesting. So when you say in the event he utilized
All right,
another
so we're gonna
inmate's
jump
phone
over.
number,
We're gonna do a little
where did you get the
different thing
phone
here.
numbers
So we're gonna jump
that
over.
you wanted them
We're
to
gonna
run to
leave
see if he was using
the
another inmate's phone number?
YSL
That I don't
trial for
remember.
just a
I
moment.
it probably just phone
We're
numbers
gonna,
that
or a little bit.
they're
And we're
probably
gonna
just,
go over to
it may
the
have been the same
hearing
phone numbers that I
involving
ran through the
open
Fulton
records
County jail
denial.
database. You know,
Or,
like
so
not knowing who
basically
Mr.
Ashley
Wright knew
Merchant
or he didn't know. I'm
had
sure I just thought, just out of
requested open
curiosity, run all
records,
these numbers. Maybe,
from
maybe I
the
had a
DA's
phone number
office.
for a family member
And
that I found.
she
Did
didn't
you follow
get
the
back,
same
get
procedure
back.
you used in all
Sorry,
the other
my
unindicted
boxer is just
homicides?
I
big
did.
old baby.
Running those numbers.
I did.
All right.
Absolutely not. You have a boxer.
Did you have jail calls, since this was 2016 that you're looking for these? Did you have jail calls for Spencer Wright that went back into 2015?
I believe so. Yes, I did. I did.
And did you find a phone number?
Sit down.
And if you don't recall, let me know and I'll refer you to
Excuse me, sorry about that. So,
your report.
so they didn't receive it. So, you know, we have the right as public, as taxpayers to request public records, right? From public officials. And if someone denies us access to those records, if they're public and not, you know, private, not going against the Privacy Act, then we can take them to court. So that's what has happened with Ashley Merchant. So she actually filed suit against Fani Willis
It's a report that we have previously
the
provided.
records were involving, you know, this was back when about the misappropriation of the funds, taxpayers' dollars and things like that. So
We
again,
just take a
in my
time for our
opinion,
morning
I
break.
truly
Okay, let's
believe
take our morning.
that the reason that Ashley Merchant did not get those records is because Fani Willis, just like my case in the superintendent's office, they refused to give me the file for the complaints for the past year for that Kimberly Turner person. So I think the same thing in this case with Fani, because Fani thinks that she is above the law here in Georgia. I think that they just refused to give Ashley what she was asking for, Ashley Merchant. So folks are just forgetting, you know. So let me just stop for just a second.
On this computer right here.
And they're going to break anyway, so.
Can I borrow get my mouse out of the bag?
All right, we'll take our recess. Miss Love, I've seen Mr. Scheid back, so now might be a good, he's not in the courtroom right now, but he's stepped in a couple of times, so.
Share again. Here we go. Here we go. Here we go. Here we go. All right, so let's go over here.
This is the car insurance trick big companies don't want you to know about. Over 90% of what you pay for car insurance is based on who you are as a.
I think she's going to argue affected his ability to comply. Go ahead.
Oh, this is
well,
someone else's.
With that being said, I'm going to say no. We could not for a couple of different reasons. The one, the cyber attack was
There was someone else
put some
commentating
stress on my staff
They
from
put them
January. But as a
live
personal
commenting
note,
for
as
their
a business record custodian,
Yeah.
I'm not sure if you're in December. So I was out of work quite some time. I broke my toe in October. After I broke my toe in October, had surgery.
Excuse that he was
A procedure in November.
for-
Had to have surgery in December.
that when
Was
we
out of the office for quite some time. had limited
That
work
because
from
one
January to
person is out of
February.
work for whatever
So
reason.
it then a cyber attack
With those
happened.
records,
So if we're talking about
come on.
personal
I'm better than
liability,
that,
let's talk
Stephen. I'm
personally
better than that.
first and then a cyber attack. So coupled with those things in my step working level and
These
resource
types of
systems
things
was
really,
difficult for this particular year. We started 2024 off
be
very
frustrated
interesting.
with the
Mhm.
public service,
Do you have any,
public records.
would you
things
say
that-
that increased, I'm sorry,
That gets
the
me.
cyber attack,
When it comes to
caused an
my
increase
civil rights.
in
Hey,
lawsuits as it pertains to any open record violations?
I don't think it increased in lawsuits because I am prideful of the work that my staff do on open records. I don't, giving my designated staff and how many records requests that I received, open records lawsuit isn't something that typically we get, right? So I'm proud of the work. So I would not say that the cyber attack contributed to that. I will say that January was an interesting month for the Fulton County District Attorney's Office and the influx of open records requests from January because of a high profile matter that the requester is familiar with. And the request in giving the dates of that particular high profile matter in the dates of those requests from the requester and so many other resources. January was February, March, April
I understand.
was crazy.
I understand. So I'm going to shift gears a bit. Thank you for that background. Are you familiar with the requester in this case?
Mrs. Ashley Merchant?
Correct.
I am familiar with her.
And how are you familiar with the requester?
First, by way of this lawsuit.
yeah, because
Secondly,
great.
Ashley Merchant has subpoenaed me a few times on various different matters. Ashley Merchant has used my name in public forums in various different forms in a manner which in my opinion lacks candor. So I do not have a personal relationship with Ashley Merchant, but she seems to often use my name in things.
And I'm sorry if I wasn't specific. Just more on a professional level as it pertains to open requests, open records requests. How have you come to know the requester?
Well, hang on. I heard lots of stuff from Mr. Bond yesterday that Ms. Merchant makes lots of requests and that he's very familiar with her. I think we've made that point.
Speaking.
Okay. Okay, so as it pertains to the critical mention records that were submitted back in January, the 44 pages of emails, I want to bring you back to that period. I know we testified at length to that yesterday and today. I just wanted to clarify, in preparing, I do want to give you a fair opportunity to explain to the court today what your process was from the receipt of that request down to the production of that request. Can you walk me through that, please?
Yes. So January 8th came. The request, if I recall, came into our open records team. Our open records team did a response. We supplied those documents. As it relates to my involvement to that particular open records request, critical mention, I cannot tell you that I had any involvement. What I can say specifically is when there are emails or requests, I do it in two ways. The first, as it relates to email requests, is my staff has complete authority to say, if you're looking for emails related to Dexter Bond's birthday party, and you know that someone knows Dexter Bond's birthday party, reach out to them and let's figure out how we can, compile emails, understanding that my staff, if you know my staff and you know about Dexter's Bond birthday party, let's get those emails and let's get it over to the responsive document. So that's one way. Reach out to the people. If you got copies, I can forward emails. I've done that. I've copied emails. I have done that. And so the second thing is, in the event that you ask for emails from a specific date range, my staff only has limited range. I think my emails go back to a year. I can then go to the IT department. IT department can give me emails but I have to fill out, I call it a matrix, a ticket, an Excel sheet. So I have to provide them several different information. It takes some time, and they have the capacity to go from a long period of time, right? To get various different emails. Those emails are given in the form, and then I can go ahead and forward them off. So to answer your question, as it relates to that critical mention, the first one, I had nothing, I did not do anything, but my team.
Okay, let me just say go over the penalty. Now, this is here in the state of Georgia. When you violate an open records request. So when you deny, and you should be given records when the public, a member of it doesn't have to be an attorney, a member of the public. So the penalty is violating the Open Records Act can result in civil or criminal penalties. For example, if someone knowingly violates the act by refusing to provide access to records, they could be found guilty of a misdemeanor and fined up to $1,000. So be sure when you're requesting open records, public records, and if you're denied, then you take it to the next level. Make sure you keep the email with them conversing with you. That's why I like to request it in via email, because they're going to have to respond via email, right? So make sure you keep that email showing that they denied your request, and then you go to the next level, which is the attorney general. Because the open records request in Georgia falls under Georgia's First Amendment Foundation, which of course protect and allow citizens to access to public records. Sorry about that. Let me restart.
Could have reached out, could have compiled documents. I will also say
When you
that
say could have, did they or could have they? Which one was it?
they did.
Okay.
Call, do whatever they need to compile a document to provide responsive records. In my experience, if someone did not like the copies or the image of the emails that was provided, then they would have called me or called my staff and say, hey, I see this particular email, may I have it in a native form? I've done that. And then I will go ahead and let them know, hey, it's gonna take some time, gotta go over IT. Here's the copy as it relates to the native form. And then I can provide them it that way too.
And did the requester in this case send you any communication following up regarding the form of the emails or the contents of the emails, questioning its native form?
No, they did say that open records request, as I testified, had several different parts. They did reference it and acknowledge receipt. And they did say that this is one part that's missing. So to answer your question.
What was that one part that was missing?
The graphs, analytical graphs therein in critical mention.
Which were located where in the emails?
I'm sorry?
Graphs as it pertains, which were located where in the emails?
So in the emails, it was mention of critical mention and then said reference graphs. The second open records request said, I want the graphs that was in the responsive documents. Give me the graphs.
The graphs that were in the attachments?
The graphs that was in the responsive documents that I gave.
Okay. And so how did you address that follow-up from the requester?
At that time, I responded and said, I do not know. It's not reasonably calculated to know what you're talking about. Because at the time, I had no idea what she was talking about.
And what were your attempts to research the graphs or the attachments that she was referring to?
At that point, I start staff meeting. Hey, I have something, critical mention. What is critical mention? What is that? Are there any graphs? Then I start reaching out to various different people. Originally, I thought it was security because critical mention, I thought it was some research device. Then I thought maybe it was, let me see, some investigative tool. I did later finally realize that it was a media tool, and at that moment start saying, educate me, what is it?
And who did you consult to educate you?
That was a Jeff DeSantis. Once I figured that out, that was a Pallavi Bailey. Hey, what is this? And then at that moment, we realized that you wanted some graphs that was embedded in the actual critical mention.
And so once you were educated on what critical mention was and what exactly they were asking for, what were your steps then to see if that information was available?
So that was, let's make a call to critical mention. Do we have, first and foremost, do we have critical mention, right? Because in January, when I got the open records request, I didn't have critical mention. So it wasn't something that I can log into. Hey, Jeff, do you have a order? Do you have a username? Let's go in. Can you get it? Oh, we don't even have critical mention anymore. Hey, critical mention. Do I, is it a way that I can get this? You don't have an account with us. So those are my steps. I did not have the graphs. I did not have anything that was embedded in critical mention because I don't have critical mention.
They were like,
And
they asked the person think she
so
is.
you called critical mention.
Me or my staff, somebody called critical mention. That was an assignment.
Do you know who called critical mention?
I don't know.
And you consulted with your staff?
I definitely consulted with my staff.
And were they able to provide you any additional information about these attachments?
No, not at that time.
Okay. And
sorry, I'm just ranting about my own situation.
given that this information were a part of these emails that were from members of your office, such as Jeff DeSantis, Jerry Murray, Fani Willis, Ms. Pallavi, did you reach out to them to have them search their respective emails to get that information?
Yes, I did.
And what if anything came up from that?
I remember talking specifically to Jeff because he was our point. Hey, do you have critical mention? Jeff did a research, gave me some emails. At that time, if I recall correctly, the graph that was being sought was dated from maybe 2021, 2022, whenever we have it. I indicated that my staff have limited access to their emails, right? They can only go back to a certain period. I know I have a good year. Anything outside of a year, I cannot actually get to. So I go through archives.
So when would you say you had to sit down with these respective members from your office to search for emails back in 2021? What year were you in?
This year, 2024.
2024. So, right, because the request was in 2024,
That's
correct? All right. So were they able to find anything in their emails?
No.
Okay. Did they make any attempts to look through their emails?
Yes.
And what were those attempts?
I remember standing over Jeff's shoulders, hey, let's look for these search terms. Do you have it? Do you have these emails? I remember IT works under me, having my IT director go downstairs and look. Do you have it? Let's look again. So those was the things that I did to.
So the IT person who's this IT person that helped you?
IT person that helped me, that I think I assigned last name Stokes to that matter.
And just give me some description, a little bit more detail as to how, what his attempts were in combination with you and Mr. DeSantis to get those attachments.
So purpose of the staff meeting, so many different interchanging parts, right? I say, hey, I need my IT department to go help Jeff, right? Simply because Jeff not an IT guy. Let's make sure, let's look at these emails, let's use these search terms. How far can we go? What have we done? And he was able to say, I cannot find anything. And actually, it was him who confirmed that it goes back to a certain date.
Okay. At any point, did your office or your team, your open records team, consult with the Fulton County IT team to get access to these records?
Yes, eventually.
Okay. And how did you do so?
As a response to the subpoena, the subpoena was very specific. It was emails to A from B with term A1, B1. I was able to use that particular subpoena, put it in a ticket, allow IT to go over all various different emails. IT, Fulton County Department, not to be confused with my IT department, has the capacity to go over so many more emails, and they was able to retrieve items in their native form.
And when we're going to get to the subpoenas, but before then, when after the action back in January, when the open records request was submitted and you received the follow-up from the requester regarding the attachments, and after speaking with your team and not being able to get to those emails, did you contact Fulton County IT regarding those attachments?
I contacted, I got that in January, and I remember saying, I don't know what you're talking about. I remember having conversations. My first contact with IT probably came in February. It was when I returned, and it was more specific, not about the attachments. It's more about, do we have a contract? Like, I was looking for various different things. Like, what is critical? I was ignorant at this time. What is that? So that was my first point of contact. February was a crazy month. About March, we start having conversations about, is it a way that I can go retrieve? What can I do? And then very soon thereafter, I think I received a lawsuit.
Mm-hmm. Okay. Have you ever encountered this issue where your team has requested emails and were not able to access attachments in those emails?
Yes, it happens often.
Okay. And how does your office address that?
So the first thing is, if I want to know specifically what the requester is looking for, right? So rule number one is, let's pick up the phone and let's try to communicate. What's going on? What are you looking for? Because I can try to figure out if there's a better way to get it, right? Then two, it's, hey, let's sit down with so and so and let's do. My attorneys are busy. Let's do some research. Then three is, let's go to the IT department. So it's like a 1, 2, 3 step.
Mm-hmm. Okay. Now, just to be clear, did you contact Fulton County IT team, or was it the IT team that you contact within your office?
Both.
Okay. And were they able to help you to get those attachments?
At that time, I do not recall. I did not get those attachments, so I'm gonna say no.
Okay. And so as a result, you provided those pages, those emails that consisted of the 44 pages, correct?
Well, those 44 was prior to me even knowing what critical mention was, but they was provided in response to an open records request.
Okay. And those were your efforts made after being notified by the requester that you were seeking these attachments?
Those is my efforts for the specific request that she raised and saying she was missing. Those were my efforts.
Anything else that she followed up on in terms of what she was missing from the original provision of documents?
That was the only thing.
Okay. Now, so nothing about contracts, payments?
No.
Critical mention?
She did not follow up.
Okay. All right. And now we're at the subpoena stage of this lawsuit. Who compiled those records? Who compiled those records in response to that subpoena?
IT department at my request.
Okay. And how did you submit that request?
I call it a ticket. Some people call it a matrix. Some people call it an Excel sheet.
Mm-hmm. And what did you put in that ticket?
Exactly. Copy and paste it from the subpoena. The to, the from, the search terms, the search items, you can go ahead and put in the ticket. Make sure that you are hitting those hot button issues. What I do know from my conversations with IT, they always tell me garbage in, garbage out. So they're constantly, hey, you did not do this. I recall, as it relates to that subpoena, being very specific because it was these search terms to our employees, right? So that allows IT to really go, they got a limited database to work. If your request is any emails related to critical mention, the garbage in is going to get garbage. You're not going to get as much records because your search term, who are you asking? Who is it from? Is anything specific? So I like to think that the subpoena was specific and IT was able to help me on that.
So your testimony today is because the subpoena was more detailed as opposed to the original request, which is the reason why you got different results or different emails?
I knew exactly what they were seeking for in the subpoena. I knew exactly where to go. I was educated at that time because it was laid out. I went to the right source. They was able to pull I didn't even have to go to my staff at this one. And they was able to pull my files through archives and pull any and all records.
Mhm. Were you surprised by the amount of emails that came back from IT as a result of the subpoena production?
I don't know if I had an emotional reaction at all.
Okay, that's fair. Moving on to the forfeiture request, the request regarding the forfeiture reports. You testified that you provided an equitable share agreement. Were you aware of the forfeiture reports that were shown to you yesterday during yesterday's hearing?
At the time of I received the open records request, no, I was not aware. No, I was not aware.
So is it uncommon for your office to submit documents of that nature outside of your notice or outside of your consent?
Yeah, I would say yes, because some of those was filed, right, with the state. And with the documents that I saw, the first one, my name wasn't on. The second one, my name or my staff wasn't on it in both the first and second one. The third one, it appears that my name was typed, but another email. So to answer your question is, it's not really in my division.
And what I recall from your testimony yesterday is that you were not aware of this document. When did you become aware of this document?
When my counsel presented it to me.
And do you remember a time frame?
Within the last few weeks.
Okay. And so it's safe to say you weren't aware of this document back when it was requested in January?
No. In January, honestly, I did not know what her request is. In my experience, I get, again, of the 1,000 requests, only a certain percentage comes to me. And based on my experience, I can kind of gear if someone really wants a specific document, and I can jump on the phone and say, hey, what are you looking for, right? In my experience, when I have a lot of open records requests is extremely broad, things become a little bit more difficult. This one, in my opinion, was very broad, but I was guided because of my expertise, right? As a county attorney, I filed with the local governing authority. Mm-hmm. And because I knew what that meant, right? I was like, okay, I know who the local governing authority is. My next step was clerk of the Board of Commission. I'm looking for forfeiture documents because, as I recall the request, there wasn't a distinction between state and federal. Looking for forfeiture documents. Do I, on behalf of this office, or does this office file forfeiture documents? The answer was yes, the equitable sharing agreement. Mm-hmm. Does it talk about property? The answer is yes. This must be responsive. Right. And this was a case where I went, honestly, in my opinion, over and beyond, because I didn't know what she was talking about. But I was like, oh, wait, this is really in my wheelhouse, right? Let me make a call. Called the governing authority. She said that we filed it by state law. The governing authority gave it to me. And then I indicated, trying to communicate, we believe this is what you're talking about. And I gave it to her free of charge in response to so many other things. So.
Mm-hmm. And you provided that report prior to the filing of the suit, correct?
Yes, January 26th, along with my letter.
And was there any and there was some follow-up communication between the requester and your office stating not this equitable sharing agreement, we're seeking something else. Do you recall that communication?
I don't.
Okay. And if you knew that this, strike that. Now, in terms of the request regarding the non-disclosure agreements, you testified that originally when you received the request, you thought the requests were pertaining to media. And that's the reason why you didn't provide it, because your office didn't possess any NDAs regarding the media, correct?
That's correct.
Now, were you aware of any NDAs at that time of at the time of the request? Were you aware of any NDAs that would have been responsive to this request?
No NDAs that prevented my staff from talking to the media. I was not aware of anything.
And at what point did you, and was there any follow-up by the requester regarding this response when you indicated that there were no responsive records?
I don't believe that through the portal. And of course, Ashley Merchant and I don't. converse via email, so I don't believe so. no.
Mhm. And at what point did you realize that she wasn't, well, yesterday you testified that you came to know about, I'm sorry, yesterday you testified that you gained clarity as to the request, but it was not limited to the media and that it was a request essentially generally addressing confidential agreements. When did you learn that?
During the course of this hearing.
Give me a time frame.
Within the last 2 weeks, I do recall the subpoena being extremely more specific. And if I could recall correctly, she took out any mention of media and only focused on confidentiality agreements. And once that happened, only confidentiality agreements, that's when I start conversing who has confidentiality agreements. Did, in my opinion, my due diligence to provide what I had as quickly as possible.
Was it brought to your attention by someone?
Yes,
Who was it brought to your attention?
my counsel.
Okay. And after learning that this request was encompassing not only NDAs for addressing the media, but that it was addressing all NDAs, what did you do at that point?
At that moment, I acted as I would with any other open records request. What is it? Who has them? Because this was a situation where my staff, we don't sign them. So my direct reports, let's be very clear. Who has them? Where are they? Do they exist? What are they? Just generally confidentiality agreements. And I knew they did. I just had to go figure out where they were.
And after that research, were you able to discover any NDAs?
Well, confidentiality agreements, I don't call them NDAs.
Okay.
Because my confidentiality agreements is, protect my victims' rights. Make sure that what's going on, you don't disclose. We hear a lot of serious stuff, a lot of private stuff. So and I had to go into that particular area to see what was going on.
And so were you able to locate confidentiality agreements?
Yes.
And what did you do at that point upon locating them?
Gave it to my counsel.
To do what?
I'm assuming my counsel gave it to Ashley Merchant.
But you gave it to your counsel to give it over to the requester.
Oh, yes.
Okay. Now, do you believe that the provision of those disclosure agreement satisfies the request?
Now understanding that it wasn't limited to media, I do believe that responsive records in which I was able to find at that time satisfied the request.
Do you believe that there are any additional confidentiality agreements?
I have no reason not to believe there are.
Is this something that your office is researching ongoingly?
Yes.
Okay, and is it your plan or the plan of your office to provide those documents as they're made available to you?
That's my next Tuesday staff meeting. I got a list of things. That is one. Kind of been busy this week. So if there are some more, this is why I assign things. Hey, can we let's talk about that. Let's see if they exist. Where are they? But I don't know. But I'm pretty sure that on Tuesday, 11:30, I'll be updated on the issue.
Okay. There was some testimony and some questioning regarding possibility of altering any documents that may have been provided to the requester, specifically as it pertains to critical mention documents. Is it your testimony at all that these documents, that you have any reason to believe or any suspicion to believe?
I don't know if you all, I don't know if you all caught it. I think I probably was talking, sorry about that. But so back on the YSL trial, they are actually waiting for Zachary. Now everybody's on lunch right now. They're supposed to be back at 12-ish, 12:50, if I'm not mistaken. So, and what we're going to do is we start a little after they start because I like to, prepare ourselves for our conversation. But so just to let you know, we're going to go back
these
over.
documents have been altered, the critical mention emails?
No, not the substance of the emails. I do not have any reason to believe that the substance of the emails has been altered.
And so even after the illustration that took place a few moments ago, where you noticed that there was a to and from missing, the dates that were missing, and even the subject line was missing, do you still hold that position?
I do. I don't think any substance have been dismissed.
And why do you feel that way?
First and foremost, I trust my staff, right? I think my staff is well trained. I'm thinking about the person who's designated as my paralegal for this particular matter. She's a trustworthy person. That's number one. Let me start with my staff. Number two, it is completely common for my staff to reach out and try to take particular emails and say, hey, given January, given what was going on, are these responsive, right? So it's completely common that I give you those documents. It has happened, and it will continue to happen, that a requester receives documents and they say, hey, I'm looking at this document. Can I have it in native form? It happened to me last week. And then at that moment, you assign and say, hey, I need this particular portion in native form. It's my experience when someone is really looking for something specific, they're on a search for something specific. So if it's no moving target, I have an opportunity to sit down, communicate with you to figure out what you're doing. The problem is, I like to get you records as quickly as possible for open records purposes. When I engaged in native form, that's not me, right? I'm getting emails from various different staff. When I go into native form, I'm going beyond my direct team, beyond my office to Fulton County IT, and I'm submitting a ticket that falls in line with every other ticket that they're doing. So I typically, to let them know, I'm giving you a copy of this. If you need native form, it's going to take some time. And a lot of times it takes some time. Right now, I'm in a discovery matter, gave them a copy. It's sufficient, but I have to give them a native form. And I think we might be 6 weeks. It's a long time. Forgive me, I don't know a time frame, but it's a long time to get those forms.
And is it a practice of your office to modify or redact, well, I'm sorry, not redact, but modify or manipulate documents outside of redaction? Is it a practice of your office to do that with documents that are produced by way of
Absolutely not.
open records?
Absolutely not.
Okay. And has there ever been a situation where your office has ever been accused of doing anything of that nature?
Absolutely not. Not under my leadership. Absolutely
not. And what is your position or the understanding of your open records staff as it pertains to manipulating documents? Do you have a policy in place as it pertains to that?
The policy, I think, that we talked about, all records should be maintained in accordance with the Open Records Act. That's specific. General, we take an oath to the highest esteem, right? So with any allegations of anything that violates that oath or violates the law is seriously taken under the leadership of Madam DA Fani T. Willis, and as the board of, and in my capacity as deputy of operations, that won't be tolerated.
Okay. Were any of the documents that were produced to the requester manipulated or revised in any way?
No.
Were any of the documents provided to the requester redacted in any way?
Yes, she showed me one that was redacted.
And as it pertains to your production of documents as a result of the subpoena, who handled the redactions in that production?
I can't tell you specifically who.
Okay. And what is the policy or practice within your office as it pertains to redactions?
It depends.
Mm-hmm.
So a lot of times it depends on what I'm redacting. It depends on what the exception is. If I'm doing attorney-client privilege, right? If I'm returning confidential work product, if I'm doing privileged information, social security numbers, depending on the level of it, determines how I'll assign. If you know, so there's levels to it.
Testify.
Okay.
Leaving the
we
house.
are moving on to the list of the requests regarding the list of hirees and their date of employment. You testified yesterday that your office does not maintain such lists. Is that still your testimony today?
That's still my testimony today.
How do you play? So who's responsible for payroll in your office?
Ultimately me.
Okay. And how are you able to, or do you use a list to to process payroll in your office?
A list, no.
And would Fulton County have a list of employees and their hiring dates?
So my conversation with the Human Resources Department said that Fulton County will have a date. They should have it's not necessarily a hiring date. It is a date in which they move to various different specs, so special in class. So they did say they have that, but it's not reserved for attorneys. It's for all employees related to Department 480. So it's almost like a pay registry for a class. So they do not have that.
So is your answer yes or no that they have that list?
No, they don't have that list.
Okay. Was Deputy Shalonda Miller ever involved in the requests that were submitted to your office or subject to this lawsuit?
No.
Do you recall that letter that was shown to you yesterday that had Shalonda Miller as the custodian of records on a letterhead? Do you recall that letter?
Yes.
And the requester has alleged because she received that letter that she was involved, Shalonda Miller somehow was involved in the processing of this request. Is that your testimony today?
I'm not sure I understand the question.
So as a result of this letter being received by the requester with this letterhead showing Deputy Shalonda Miller on the letterhead, there's a position that has been taken by the requester that Deputy Shalonda Miller had some level of involvement as it pertains to the request subject in this case. Do you believe that to be true?
That is not true. And if I can explain, during the cyber attack, our job as my particular Deputy Miller is on the Fulton County side. I am on the DA side. This is an opportunity for me to consult with the county attorney and say, how are you handling cyber attack? Because my one person over here cannot get to the system. Deputy attorney or the county attorney, I can't tell you who, said, hey, here's a letter that we can update our requesters. I took that particular letter. I remember being at a particular staff meeting and saying, hey, let's use this letter and let's update everybody, not just specific to this requester, but let's update everyone as it relates to the cyber attack because we expect significant delays.
Okay. So it's your test letter was provided by the county just to address the cyber attacks, and that is all?
Yes.
Did it have anything to do with the actual underlying request per se?
No.
Okay. Moving on to the request regarding rebranding of DA Fani Willis. Does your office possess any materials regarding rebranding?
I don't know what rebranding is.
Okay.
So. But I do know that the office does not request. I remember the request being for bidding or something like that. Don't know what rebranding is, but if you're talking about anything related to bidding, the answer is no.
I'm sorry, to what?
Rebranding?
No, you said if you're talking
bidding.
about anything in
Bidding.
bidding.
Yes.
Thank you. I just didn't
I'm
quite hear the
sorry.
word. That's okay.
I am from Washington, D.C. That it goes a little fast. The request, as I understand it, was for bidding or payment bidding, like using various different competitors to see if there was a bidding process for the purchasing of such and such.
Yes, and I'll read the request as it pertains to rebranding. Any payments, requests for payment, process for hiring bids and paying vendors for rebranding material. Did your office at the time of the request possess any of those items?
No,
And what was your response to that request?
we do not possess such items.
And was that response provided to the requester prior to this action?
Yes,
And was there any follow-up by the requester once you provided that response?
not to me, not to my knowledge, no.
As it pertains to the request regarding promotional material, any payments, requests for payments, process for hiring bids and paying vendors for promotional materials, including promotional brochures, flyers, or mailers. Did your office possess or have any control of materials responsive to that request at the time of the request?
I don't know.
And what was your response to the request? There was no responsive documents, correct?
Yes,
Was there any follow-up by the requester after that response?
no.
When did you come to learn that this was an issue in this litigation?
When you brought it to my attention.
When was that?
Within the last couple of weeks.
And is it your testimony?
This is what we're going to do because I just found out that I don't think I'll have to do a little research on how I can, like, I guess, stream while the news is streaming, because I thought that was legal. I thought it was, because this is a reaction. So I'm going to come out of this one. I'm going to restart another live after Mr. Zachary gets into the courtroom. And then, but I won't be streaming on screen. So we'll just have to communicate with each other as we're watching it or as I'm watching it. And then I'll just have to disseminate information. So that's how we'll have to do it until I figure out how I can actually stream without crossing any violations or violating any guidelines, because we're trying to grow our channel and we don't want to April TCG, we're just getting started. We don't want to mess up our channel. So we definitely don't want any copyright or we don't want to violate any guidelines. We were reacting and using the information under the Copyright Act of 1976 for educational purposes. So keep that in mind. However, if you haven't already subscribed, be sure to subscribe, like the video. Thank you so much for joining. Keep in mind that all comments are welcome. And I appreciate you. We're going to grow and grow. We're going to, we'll get it together. We're just starting, so we'll get it together. Thank you. And I'll be back in probably about an hour. All right. Peace.